We're still going live. Just one second. One last technical issue to iron out.
Electronics.
And we should be good now.
Okay, let's pray. Almighty God, Heavenly Father, we ask for you to be with us and upon us here tonight. Please open our minds that we may hear what's said, take it in and understand. Give us wisdom so that we can do what your will is and what's best for everyone here tonight. We thank you for our help being as well as it possibly is. And in Jesus Christ, my Savior's name, I pray. Amen. Amen. I'd like to, on behalf of the Alamance County Board of Adjustment, I'd like to welcome everyone to this March 21st, 2024 meeting. My name is Ike Holt. I'm the chairman. A little later in the meeting, each one of the members will give you their names and I'd like to, before we really get into the nuts and bolts of what's going on, I'd like to go over a little bit about just exactly what the Alamance County Board of Adjustment is. It's a new board to Alamance County. We are appointed, the members and a couple of alternates by the Alamance County Board of Commissioners. So obviously we serve at their pleasure. We are what's known as a quasi judicial board, which was a term, to tell you the truth, I'd never heard of until I come on this board. I'm not sure that I really understand 100% about what it is, but I've read a lot. And the best way I know to describe it, we are sort of the jury and judge all put together. We are heavily regulated by North Carolina general statutes. We can't necessarily do just what we think is the best thing to do. We have a certain decision-making process that we have to go through. And over on the board that you'll see later on, Mrs. Rodriguez, there's 4 questions that you have the burden to address and to satisfy our opinions as to being able to grant a variance based on those 4 questions. They're very extremely important. We can't go on anything other than facts. Like I said, we're sort of like an appellate court. You know, the planning board's already turned everything down, and now you're before us, and we can override what the planning board has done. But in having the power to do that, we have to meet certain regulatory different things. Also, as you'll learn a little bit later on, everybody that wants to speak for us has to have standing. What that means is you can't just, somebody in the audience just can't come up and give their personal opinion. First of all, I have the power to decide whether or not that person has standing, and if they don't like the way I might rule on it, then they can appeal it to the entire board. So that's something I'm not sure that we'll have anybody that will address the board. You will be required, as well as the county staff, to take an oath tonight. And if anyone in the audience wants to speak to us, if I find that you should have standing, you'll also be required to take an oath. So this board is not just a fly by night kind of thing. Our decision, should it not be in favor of you, is you are able to appeal that, but the only appeal from us is to go into the court system in the state of North Carolina, which would be Superior Court. I trust that the members on this board are fair. I've known most of them for quite a few years. And I think they're level-headed people. There'll be times going through here tonight that I may intentionally slow things down a little bit. Because we are not allowed by law to have discussed this case beforehand. We have been sent a packet of information by the county staff that has give us, we have, for example, a copy of your application. And we have also done other things ourselves that I'll touch on a little later. And before we get to your part of this meeting, we need to move on to our old business. And so for a little bit, we'll be just doing some paperwork stuff here. So the first order of business is we have to approve the minutes of the March 7th, 2024. BOA, if that doesn't offend anybody, that's the way I'm going to sort of refer to this. So I trust the members as having an opportunity to address and look at those minutes. And if so, I'll be glad to entertain a motion to pass the minutes.
Motion to approve.
Since there is a motion and a second that we approve the minutes of the March 7th, 2024 Board of Adjustment meeting. Is there any discussion? All in favor say aye.
Aye.
All opposed, nay. They are approved. The next thing that we need to do is approve or adjust the Alamance County Board of Adjustment rules of procedure. I trust everyone has had an opportunity to read over those as well. I know that it looks to me like that the discussions that we had at our March the 7th meeting has been taken in to note here in our minutes. And it appears to me like everything that we talked about was covered. So does anyone have any comments on, they see anything that needs to be corrected about the rules of procedure? One thing that I'd like to say is that these rules can be amended in the future if necessary. One, it talks a little bit about, not arguing that a little later. So, anybody, are we ready to vote on the rules of procedure?
I'll make a motion to approve.
Okay, there's a motion. Do I hear a second? There's a motion and a second that we adopt the Alamance County Rules of Procedure as recorded. Any discussion? All in favor say aye.
Aye.
All opposed? Okay. I believe that takes care of all of our old business.
Mr. Chairman, there's one more item with regards to the 2024 meeting calendar.
Oh, I'm sorry. Thank you. I saw that, but didn't read it. Look at it. The last page, I believe it is, in our packet, is the proposed agenda for us for meeting. I believe it's the third Thursday, if I'm not wrong, at 5:30 here in this room. Again, this is one of those kind of things that can be played with on down the road under the rules and procedure if necessary. If we see that it's not working out going forward. That's a pretty cut and dried sort of thing. I'll be glad to entertain a motion.
Motion to approve.
Second.
There is a motion and a second that we approve the 2024 Board of Adjustment calendar. Is there any discussion? Okay, all in favor, say aye. All opposed? Okay. Now we go on to our new business. I'm going to formally start the proceedings now to cover the variance request.
See, we need to dictate.
Spot with my husband, if that's okay, because my daughter is upset out there. Would that be an issue?
What's that?
My husband's here now. He brought my kids. My daughter's upset outside. Would it be okay if me and my husband switch spots?
Certainly.
Okay, thank
No,
you.
just understand if, after I submit the oath, or everyone takes the oath, if you should so inspire, speak, you'll have to take the oath.
Would it be okay if my daughter was in here with us, or would you prefer for her to be out? 'Cause she's a little upset.
You
Yeah.
know, if she's gonna be a little fussy, it might not be a good thing.
Yeah, I'm so sorry about that.
That's okay, understand. Second.
Since we have a moment, Mr. Chairman, if you want to sign today for the adoption of the rules of procedure, and I'll sign there at the bottom.
Mr. Rodriguez,
Yes, sir.
glad to see you. On the first item under new business tonight is we have a member absent, Mike Wilson. We do luckily have a couple of people available. Tom, if you would, could you please come forward? Switch over. Let the record show that Tom King is alternate number one. And as set out in the guidelines of our rules of procedure, that's how he was selected. Also, I'd like to, for the record, to note that he was sworn in at an earlier date than when the rest of the board was, with the exception of Mr. Cobb. And I understand, Matthew, that Mr. Cobb has been sworn in previously.
Yes, sir.
Correct.
Correct.
Okay. All right. First thing I need to do is, give out a little bit of history here. This is case number 2024-001. We, it's applicants are Pedro and Kirsty. Is that correct? Is that?
Yeah, Pedro, yeah. Kirsty, yeah.
Pedro and Kirsty Rodriguez at 4191 L Lawrence Trail, Rim, North Carolina, 27253, way down south in Newland Township.
Oh, yeah.
Okay. Mr. Rodriguez, you may have missed a few important things that we said when I was sort of going over how this works. We're very similar. The Board of Adjustment is a quasi judicial board. That means we're sort of like the jury and judge all in one. What we'll do here tonight is hear two sides. The county will present their side of this situation, and you, of course, will have an opportunity to present your side. There are 4 questions that must be answered to us, that must be proven by you for us to base our decision. This board is heavily regulated. We can't just do what we might want to do. We've got all of our terminations has to be based on findings of fact. Hearsay is no good. What you think might be the case is no good. It's got to be based on fact. So Hope I could. Did I need to cover anything else before he got in here? You think there's anything else relevant that I need to tell Mr. Rodriguez? Okay. For the record, and before I swear anyone in, is there anyone in the audience that feels as though they might have possible standing to speak before this board tonight? Okay. If one of you would like to come forward, I will have some questions for you.
Give me a minute.
That's all right. As a matter of fact, if you need to sit down, that's okay.
Had it right here for place 7 weeks ago, just give it a minute.
Oh, okay, okay. For the record, you need to state your name.
My name is Eddie Vaughn.
And where do you live, Eddie?
I live at 4173 Lawrence Trail. I live on the west side.
Okay, so you're a neighbor?
I am.
Okay. Again, should I decide that you don't have standing, you can appeal it to the entire board because they're gonna
Sure.
hear what's being said. So what is your basis of coming tonight?
Well, the pastures that goes around the houses of the property that Pedro and his family own, we've always been neighbors. And I've got them leased for cows and whatnot, and kind of concerned about when we moved out there, it was a very open community.
Okay, let me interrupt you here.
Yes, sir.
You need to be factual about what you think the outcome of this case would mean to you. In other words, if you
Loss
might
of
think it
property.
would be a monetary problem
Mhm.
or a traffic problem on the road or whatever, it needs to be factual. Just your opinions won't work with us. We've got to know specifically what your complaint is.
Possible loss of property value.
Okay. Do you have any means of to support that, of why you think that?
The paperwork and what I've read says that we live in a housing development.
So do you have any background paperwork to show us just to prove what you're saying?
Did we bring that? No, we did not, but it was given to the 4 adjacent landowners, and it came from the county,
Any other?
the letter.
Yes.
Do you have the letter? Isn't that the one that states it?
So on that there. Asking for a minor subdivision variance. It's not a subdivision.
Okay, so that doesn't have anything to do
Okay.
with the value of properties.
Okay.
I'm sorry, I'm gonna find that I don't think you have standing.
Okay.
One of the reasons is you don't have anything to back up
Okay.
what you're saying.
Mhm.
I'm sympathetic to your
Oh,
argument,
I'm good.
but we need documentation
Mhm.
to back up what you're saying.
Mhm.
For example, if you had hired somebody, an appraiser
Mhm.
or a realtor to tell you that it's going to devalue your property,
Sure.
then I would find that you had standing with no problem. But, thank you.
I'm good with it.
I'll be glad to.
Mr. Chair, is there any way for us to see where Mr. Vaughn, his property is in relation to
I just pulled it up.
this?
I think you.
Is there any way to pull GIS up to see?
Yeah, it may take us a moment, but you probably pull up a GIS map. Yvonne, what's your address again?
4173.
4173.
It's always a hands.
I think so too. I'm waiting for them to.
All right, that should be switching over. Here's the applicant's property. So 4191, slightly up to the right is the subject property of tonight's hearing. 4173 is now highlighted.
So they're looking at from here, it's the property to the left, the flagpole lot.
Yes, sir. On the left, like a left-handed boot or a left-handed pipe.
And the pasture land
Is
that's
the
leased is
Goes all the way around,
Okay.
the Martinez's house and then
Okay.
the back of, Barbara's house, the first house as you come in the dirt.
Okay. Thank
Yes, sir.
Does that answer your question, huh?
you. Yes.
Okay, ma'am, we'll be glad to hear from you.
I'm gonna sit, please. I'm gonna sit, please.
Okay.
I live next door to the Rodriguez's. And right now, there's a problem with communication with us.
I'm sorry, ma'am, you got to speak up.
He has communication problems with me right now. I don't know why,
Oh,
but he
okay.
has strings on my side of the property only.
Yes, ma'am.
And he had markers every 2.5 feet. Just preventing me from clutching and doing what I need to do. I've lived out there for almost 30 years.
Yes,
I
ma'am.
moved out there for the privacy and that space.
Yes, ma'am.
And it scares me that it's going to turn into a development.
Okay.
Ma'am, what was your name?
Barbara Honeycutt.
Thank you.
I own the
And-
land that goes all the way around the Rodriguez's. Almost 10 acres.
Okay.
Leave these two parcels right here. Yes.
The road is actually part of my land too, coming in. Yes,
So you have a right of way out to Highway 87?
yes, sir.
Her land actually goes all the way to 87.
Yes.
Where I see it, the right of way, your
Yes,
property all the way in.
yes.
Uh, I'm going to also say that your testimony is not going to be relevant tonight. If you'd like to appeal to the entire board, that's fine. There, you know, everybody's got property owners. And because you and Mr. Rodriguez has a communication problem, that's certainly not a factor that we can take into consideration.
But if you want to be a good neighbor, you try to be a good neighbor.
Yeah, yes, ma'am. I'm with you 100%. But I'm afraid that won't be anything that, from our standpoint, that we'll be able to consider. That's what I was talking about earlier tonight. We're regulated
I'm
really
afraid
heavy.
to go out of my house because of the hostility.
Yes, ma'am. I'm sorry for that, but my ruling is that we won't be able to consider that tonight. Okay, for the people that's involved, and Mrs. Rodriguez, if you'd like to come back in while we administer the oath, so if you do need to speak.
My little girl.
I'll grab my daughter real quick. You can grab her.
No, both of you, no, both of you.
Yeah, I'm gonna bring her out here.
Oh,
Yeah.
okay.
We have two. Sorry.
That's all right. Two pretty little fellas. Well, I'm gonna make it tough again. I'm gonna ask, in a minute, I'm gonna ask you to stand again. For the record, the people that's going to be sworn in today is, if you will, state your name.
Matthew Hoagland, I'm the planning director for Alamance County.
Ian Shannon, planner 2 for Alamance County.
And Mrs.
Kirsty Rodriguez.
Pedro Rodriguez.
And you are the applicant, right?
Yes, homeowner.
Okay, thank you. If you would please stand for the oath. And raise your right hand if you can. Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I do, yes.
Thank you. Be seated. Now, you get an opportunity to know who we are up here. As I said earlier, my name's Ike Holt. I'm the chairman of the planning board. And going by alphabetically, Mr. Cobb, if you'll state your name and for the board. And for the record, for the board, I'm sorry. Ray Cobb. Ms. Hyder,
Deborah Harlan.
Mr. Owens,
Mike Owens.
and
Tom.
Mr. King. Okay, thank you. So we got that on the record now. Next step is I want to poll each member individually as to whether or not they have been, feel like they have any conflict of interest. The chair does not feel like he has any conflict of interest. Mr. Cobb, do you?
No conflict of interest, sir.
Ms. Hyder? That's a no.
Yes.
Mr. Owens?
No, sir.
Mr. King?
No, sir.
Okay. Does any board member have anything to disclose to the board as to maybe a site visit or anything else? And I'll start out. I have looked at the GIS in Alamance County, looking at your lot and how it's in proximity to neighbors. And so I've looked at that information online. Does anyone else have anything?
I rode by the property.
Okay. That's good. That can be helpful for us. Thank you.
I also looked at GIS. I was kind of look at the pattern of the development along the private road.
Okay, okay.
I have not looked at the GIS, however, I did, do a job in the gentleman built a cabin at the end of Alamance Trail. I went over and just went with him maybe 2 years ago, so I have been up and down Alamance Trail. As far as specifically this particular piece of property, no.
Okay. Let the record show what was recorded. I believe now we're ready to ask the staff to present the county's reasoning for turning down this this particular variance or this particular subdivision. So, Matthew?
Mr. Chair, we opened the hearing yet, and I missed that.
Yes,
Okay, we did.
I thought we did. When right after new
I may have
business.
missed.
Yeah. Okay, Matthew.
Thank you, Mr. Chairman. Pedro and Kersey Rodriguez are requesting a variance from the provisions of section 6.9.45A of the Unified Development Ordinance, which states, quote, "In the calculation of lot areas, lot depths, and lot widths, land within any street right-of-way or railroad right-of-way easement shall not be considered." As well as section 6.9.4E1, which requires that each parcel on a private road be at least 1 acre in size. Mr. and Mrs. Rodriguez own the 2.04 acre lot at 4191 L. Lawrence Trail, Graham, in the Newland Township. L. Lawrence Trail is a private road. Mr. and Mrs. Rodriguez are seeking to divide their existing 2.04 acre lot into lot 1, which would total 1.03 acres with 0.25 acres within the right of way, and lot 2, which would total 1.01 acres with 0.12 acres in the right of way. Respectively, this would result in an area outside the right of way for lot 1 of 0.78 acres and for lot 2 of 0.89 acres. Neither of these lot sizes would comply with the 1 acre lot size minimum requirement of section 6.9.4E1. Given that the resultant lots would total less than the required 1 acre outside the right of way, the planning department cannot administratively approve such a division of property. Planning department staff emailed the surveying company working with Mr. Rodriguez on February 7th, 2024, letting them know that we cannot approve this subdivision as it is laid out based on the substandard size of the lots. On February 8th, 2024, planning department staff informed Mr. Rodriguez of the option to apply for a variance. Mr. and Mrs. Rodriguez then submitted the variance application on February 15th. The standards for granting a variance are found in section 2.3.1A of the UDO below, which I will read now. When unnecessary hardships would result from carrying out the strict letter of the regulations, the Board of Adjustment shall vary the provisions of this ordinance upon a showing of all of the following. 1, unnecessary hardship would result from the strict application of the regulation. It is not necessary to demonstrate that in the absence of the variance, no reasonable use can be made of the property. Number 2, the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are that may be, that are common to the neighborhood or to the general public may not be the basis for granting a variance. A variance may be granted when necessary and appropriate to make reasonable accommodation under the Fair Housing Act for persons with a disability. Number 3, the hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with knowledge that circumstances exist that may justify the granting of the variance is not a self-created hardship. And number 4, the requested variance is consistent with the spirit, purpose, and intent of the regulation such that public safety is secured and substantial justice is achieved. As you deliberate today, board members, please evaluate this variance request on each of the individual criteria and make a determination on each for the public record. Pursuant to section 2.3.31 and state law, a 4/5 vote is necessary to grant a variance. At this time, Mr. Chairman, I would like to enter all documents related to the variance case into the public record unless there is an objection.
I object. I think we need to discuss some of the emails that you sent out to us.
Okay,
We'll take that up after you finish after the presentation, so.
thank you, sir. I will also note that a hearing notice sign was placed at the property and letters notifying adjoining property owners of the hearing were mailed in a timely manner to satisfy statutory requirements. I will also note for the record that an altered version of the email thread involving Mr. Rodriguez, planning department staff, and professional surveying firms was sent to all parties withstanding in this case on Monday, March the 18th. With that, Mr. Chairman, I'm happy to answer any questions that you may have before proceeding with the hearing.
I believe I'll wait and we'll address questions after the Rodriguez's present there, and then we'll open it up for questions for them. Mr. Rodriguez or Mrs. Rodriguez? Before you start, let me re-emphasize, because I don't think you were injured, and we certainly can't read that.
That's larger. And Mr. Chairman, I do want to point out that the information that appears on the board
They were mailed out.
there's a copy of it on the desk.
Oh, okay.
And each board member should have a copy as
Okay.
well. So specifically, sorry, I don't mean to interrupt, but specifically, it is 160D-705D, which is the criteria for granting a variance. That the documents also include criteria for standing and in the specific sections of the UDO, which they're requesting a variance from. You should have a copy on the desk.
Mr. Rodriguez?
Yeah. So you want me to explain what's the situation or how, or what we plan on going or?
I need, what you say before us tonight is, needs to be factual. And you need to address each one of these 4, I call them hurdles, for lack of a better term, because for us to grant you a variance, and you're going to hear some debate among us because there's some issues here. You're going to need to address those in a factual way.
Okay. So from what I read, it looks like we check every mark on this with the unnecessary hardship from that, the lot sizes. Because we're not one of the banks we're trying to get financed through, won't finance it 2 homes on 1 lot. It has to be separated lots. So.
Do you have any documentation to back that up?
No, I don't, but I've talked to multiple like finance companies. They won't finance
Yes, sir.
second
I
house.
understand.
Right.
I understand. It's important now to remember when you're making your presentation, it's got to be factual
Mhm.
for us, okay? I'm not disputing your word.
Right. No, I should, I should brought the paper, but no bank will finance a home that's already on a lot with a lien on it. But the home that's on there already has liens, so they won't finance. Basically, they wanted to have 2 separate lots in order to finance the home, a mobile home.
Okay.
Yeah, that's, and, basically, when I was reading here, on the second one, it said, the hardship results from just the location size of the lot. Um, and on the third one, none of this hardship resulted from the actions taken by the applicant or the property owner. So that would, I guess, for the third one in question. And on the fourth one, it said requested variance is consistent with spirit, purpose, intent of regulation, such as the public safety and the. Basically, it doesn't, it won't cause anybody harm, any other lots or anything. So that's pretty much what I read. Looks like it checks out every single, yeah, every single part of the section.
Is that all you have to present to us?
Yeah, I mean, I wasn't 100% sure how this worked. It was our first time doing this.
Yeah, well, you know, we we understand. As I explained earlier tonight, most people don't even know what a quasi judicial meeting is all about. And again, as I explained, I think when your wife was in here, we are regulated by law that we have to have findings of fact to make our determination. So,
Oh, and if I could add, when we talked to the plan department like a year ago, and we had like that it was possible to get done. There was no, like, we wouldn't have a problem getting it done until the very last time we brought a second surveyor out there. And that's pretty much it. At first, we were allowed to do it, and then, I don't know, I guess whoever was in charge of the planning department at that time, I guess didn't have all the facts right when I emailed them. So, what do you see on all these emails?
yes, we've seen those emails.
Okay. That's pretty much what I got.
Okay. To address the findings of fact for the records. Ian, I've noticed that your name is, and I'm gonna open this up now for one question for each one of us, and I'm gonna start out. I noticed that your name is on a lot of these emails from 2022. Mr. Rodriguez, by mentioning that, and I'm glad he did, has opened the door for us to address what happened in 2022. And I have some not necessarily reservations, but
Mr. Matt, sorry to interrupt. I may defer to the county attorney on this. If you don't believe that email thread should be part of the evidence, the record of evidence, then I believe legally it would be best to make a motion and dispense with that being part of the record rather than debate any of the specifics of it.
I'm not really wanting to dispense with it.
Okay.
I'm wanting to get on record that Ian is willing to testify that these emails that has his name on it is in fact emails that you participated in.
Yes, yeah.
Okay. That answers my question. So therefore, I'll be glad to entertain a motion that we accept the evidence that the county sent to us in our packet.
I believe it's been entered into the record.
Yeah, unless there's an objection, I think it's automatically entered in.
Okay, good. Thank you. All right, I'm gonna go alphabetically now and ask each member to ask one question, and then after everybody has an opportunity to ask one, then I'm gonna open it up for open discussion for questions. Mr. Cobb?
I have no questions this time.
Okay, Ms. Howard?
I don't have any questions.
Mr. Owens, I mean, Mr. King.
That, not to dwell on 2022, or well, but let me back up. Has an application actually been submitted to subdivide the property yet, or is this that precursory review, hey, is this gonna work or not?
I guess, yeah, I guess I can answer that with just a bit of context for our review process. Generally speaking, for a majority of the time, a surveyor will email us a sketch to see if something is feasible, and then later on, they will send us a plat. We have gotten an actual plat, so we would accept that as neither the actual application to subdivide,
So there's the Mylar has been
Yes.
submitted, so,
or
Okay.
yes.
okay.
As the
A
Mylar?
digital, not the Mylar, but a digital plat has been submitted.
Okay.
Preliminary plat,
Okay.
Yeah.
emails to the staff,
Yes.
Mr. Owens?
which is very common.
I'm gonna ask you a question first. You said one question.
No, just to start with, then we go over to the, on the board, that's everybody.
Whoever I want to ask questions to.
Anybody.
Oh, okay.
And then you'll have opportunity to ask more questions. I just want to make sure everybody got the chance to
Okay.
ask any specific question they wanted. That's the reason I was doing it like that to start with.
Mr. Rodriguez.
Yep.
Why are you seeking financing, refinancing?
Why?
Why?
Cause, can't pay for a house in cash.
Well, that leads to a second question, Chairman.
Okay.
I'm gonna do that.
You,
Do you live in a house there at that property now?
Yes, I do.
Well,
It was inherited to my dad when he passed away last year. But I've been so we've been on it for over, 24 years. But he passed away.
so what you're trying to say is you're trying to get refinanced.
No, I'm trying to put another home on the lot.
Okay, that's what I'm.
Yeah, I'm trying to get a home,
Okay.
another home on the lot, but the financing, no one will give me financing when there's already a home with a lien on the first lot. Cause if anything happens, the first bank, they're gonna have to go through, I guess, you know what I'm saying?
Okay, Chairman.
okay, I'm gonna open it up now for all. I have a question for Ian. I'd like to take you back to May of 2022. It appears to me in some of the emails that has now been entered into the record that county staff informed Boswell Surveying at that time that the easement of the road crossing Mr. Rodriguez's property could in fact be included in lot sizes in a subdivision. Is that what you recall?
As far as I can tell on from the email chain, I don't recall any specific discussions with Tanya or County Cattle Planning Director at the time, or Taylor Pershaw, the planner two at the time, reviewing that. From what I remember, I had initially looked at Boswell's submission at the time. I can't remember if it was before or sometime before we'd been looking at another potential subdivision along Lawrence Trail, and we're looking at it as a potential non-conforming private road. So I'd sent an email out to Boswell, kind of letting them know that we were looking at that at the time. And that was most of my involvement, from what I remember.
So have I read,
Go ahead.
so have I read the emails properly?
Uh-huh.
And that the planning director at that time, as well as a senior planner on staff, did in fact say that the lots could be subdivided and that acreage could be included in lot size? Is that a fair statement? Is that, am I reading these emails properly?
So I think specifically, one of Tanya's initial emails, and this was her email from May 23rd.
It's a lot of them, May 20th.
Yes, it's Tanya's from May 23rd at 3:46 PM. It's towards the bottom of one of the pages there.
Okay,
Tanya had told Janet with Boswell Surveyors that each lot would need to be a full acre since it's not a private road. And then later on in that email chain, there are two instances of Taylor saying that the acreage within the right of way would be able to count towards that.
So, I know Tanya's not here to ask her, but, to get back to my original question. So the, Boswell surveying was told, according to these emails, that it would be okay as far as the county was concerned to subdivide those lots and include the right of way.
Yes, that would appear.
In 2022.
Yes.
Has there, Matthew, has there been any change to the subdivision laws as to the re-subdivision of property that was maybe sold as a subdivision with a fixed amount of lots initially?
I don't believe there have been any UDO amendments to these provisions.
Since 2022?
That's correct.
Since 2022. Do you know how many lots was in that subdivision initially? With it being a private road subdivision, I know there's some restrictions about that.
When you say initially, do you mean at the time that this lot was created? or
No, I mean,
as
when
it
the
exists today?
subdivision was created.
When the subdivision was created, I don't believe we've looked at that specifically. I want to say that the plat that created this lot initially from the mid 1990s included 4 lots.
I believe
Uh,
1995.
Yeah, and at the time, the existing road, the private road was existing. Today, from our examination, there are 13, what we would call applicable lots along the private road. There are several lots that are greater than 10 acres. The subdivision regulations exempt those from certain aspects of the subdivision regulation. So with regards to applicable sub 10 acre lots, then there are currently 13 by our calculation.
Yeah, I think if you include those 10 plus acres, the amount of traffic on that road is, amount of partials on that road is upwards to 20, almost 20 partials. So, I have concerns, about the safety involved on private roads, with EMTs and that sort of thing. Yes, sir.
If I could add to that, I was talking about the non-conforming private road issue, when we were looking at, another subdivision around the time of the property to kind of the northwest. I believe it was I want to say David Allen Holt was the name on the plat. That did have to come through, and the developer had to make some road improvements up to, the last lot that they're subdividing. So I think up to where that cul-de-sac has been included to what we would call a class 2 private road for the county standards.
Mr. Rodriguez, is there a mechanism for the upkeep of L. Lawrence Trail? In other words, does everybody contribute to a fund or anything to maintain the road?
Not that I know of.
I believe I have seen, in looking at the GIS information, that there was indeed a road maintenance agreement reached at some point in time. I'm sorry. I'm not trying to hold the floor now. You guys can have
I'll
questions.
go again.
Yes, sir. Well, it's open now for all of us.
Mr. Rodriguez,
Yes.
when did you purchase that property?
2023.
Let me see, did you inherit it?
Yeah, I inherited, yes.
Well, I mean, when was the deed put in your name?
I think it was in, March 2023.
Did you have an attorney, I'm assuming, do that for you?
Yes.
Well, he should have disclosed to you that, that being part of that subdivision, that there could never be no more subdivisions of a particular lot.
Can you say that again?
In other words, it should have been disclosed to you that, that lot couldn't be, ever be subdivided.
Where were that, is there,
Well, and right here it says through the deed restrictions on your property,
mhm.
future subdivisions of lots are prohibited.
On which one? You said on the deed?
Yeah, on the lots you have, all the lots in there that started off in 1995.
Mhm.
Mr. Burns, can you tell for the record where you're pulling that from and maybe.
That's
flip
on
the
the-
page, just.
Oh, that's.
I can if you'd like me to
Yeah,
read
go
it.
ahead.
So, yeah, that is section E for private roads. I'll just read the full clause here. Private roads may be allowed in any development in which a tract of land is divided into no more than 14 parcels along the private road, and each parcel shall not be less than 1 acre in size, provided the following conditions are met. Condition A, and the conditions go through H. Condition A is through deed restrictions, future re-subdivision of lots into smaller tracts is prohibited. Is that what you're referring
Yes,
to?
sir. But, you know, basically you got to prove a hardship. And so far you haven't done that. But that being said, I feel like, Mr. Chairman, and this might be out of way, I feel like those two people do have a standing based on, not my opinion, but based on this right here in the general statute 160-1402, by easement or a covenant. Well, all the property on that subdivision, the road's going through everybody's property, so it's easement, everybody is affected, everybody. And also by the covenant on the deeds. So I feel like those two people do have a standing. That's just my opinion. I don't know if you want to let everybody else discuss it or not. If you-
Mr. Attorney, I ruled on that earlier.
There was no objection to the ruling earlier. That said, the standing question is as to that person's independent ability to assert a claim. I don't know that there's any reason why the board couldn't decide to ask questions of persons who've not yet been sworn in, but they would need to be sworn in and be willing to participate in the hearing. Does that make sense?
Yes and no.
Okay.
I guess
think
what
if
I'm,
you
I guess what I'm really referring to is my ruling earlier.
Well, you ruled and there was no objection to your ruling.
That's right.
If that's the question you're asking.
That's right. So I guess what I'm really saying is.
Well, I didn't know that we could speak and object them.
Oh, yeah, you can always object.
I think the idea is if someone can provide factual information, help us in understanding
That was the problem.
road maintenance and that.
I didn't hear anything factual. That was the problem. And that's the reason
We didn't get to ask any questions.
about standing.
Well, yeah, but I mean, I'm just saying based on this right here. I mean, if this was to go further, you know,
Leaving the standing issue aside, I think if the board were to want to hear from witnesses who might be present in the gallery, then the board could choose to do that. And they would ask that person if they wanted to participate or give testimony. That person would have to be sworn before they could give testimony.
That's still not answering my question in my mind. I don't know the process of reversing my decision earlier.
I don't think we can reverse it at this point. What I'm telling you is they can still participate, but there's a different way that would be.
we were just having a discussion. I'm not saying we gotta do it. I'm just
Yeah.
letting you know, I thought it has to.
They would be participating more as a witness.
Correct.
Than a party to the
Correct.
case.
And I believe the quasi judicial procedures do allow for that.
They do, but they also have to be sworn in.
Correct.
Yes.
Correct.
Okay. So. I think we probably need to take a vote on that as to whether allow them to open back up.
Yes, we need to be clear on what subject we're discussing is the private road.
That's right. And nothing but the problem.
Not about, that would feel like each other.
Right, right. So I'll be glad to entertain a motion to let them address us for the purpose of addressing the private road issue. Right,
Since I brought this up, I made the motion.
okay. A second.
Sure. Second.
All right.
There's a motion and a second that we allow a neighbor to testify for us as a witness? All in favor, or any discussion?
This, thank you, very much.
Yeah, right, that's what,
Yes.
road, that's in the motion, just about the road. Okay. All in favor? Say aye.
Aye.
All opposed? Okay, sir.
Thank
If you can address us about the road issue.
Yes, sir. Give me a second.
Oh, yeah, you can sit down. It's just, it's a
good.
hearing thing. is
I'm
what it is.
good. I'm used to being in front of people. Do I need to be sworn in or anything first?
Yes, sir. Yes, sir. I'm sorry. If you will, for the record, state your name.
My name is, Edgar Duvall III. I go by Eddie.
Okay, Eddie, will you raise your right hand, please?
Yes, sir.
You solemnly swear or affirm that the evidence you shall give to the board of this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Okay,
When referring to the road, and I don't know if this holds water, so to speak, on the road. I think I can still provide. Not right now. Where we tried to get everybody on the road. And we got prices on the road. For the upkeep because the road is so bad right now. And nobody. Miss Honeycutt wanted to help, but we didn't get an email back from them, but she verbally said yes. And the pipe that's existing under the road presently, if you ride down it and you look off the right-hand side, there's erosion there. There's 2 inches of water coming this weekend. The water is hydraulically under the probably 30-inch pipe that's going under in the curve. We have a lot of traffic, a lot. And it's always been that way. I've been there 21 years, I guess. And here again, it's like nobody wants to help, but the road is an issue. And it's factual. Anybody can go there at any given time and see it today. You know, you can see where the rock, if you're going east towards 87, the water runs down the road because it's been scraped flat over the years instead of it having a hip in the middle. And the water runs off the left side going towards 87. And it's eroded, I don't know, probably that far into the road now. And it's taken all the rock and gone either underneath the pipe or through the pipe, and it's on the right side. And I mean, you put more people, you put more vehicles, what's gonna happen? It's just gonna increase. That's the issue with the road. But we have tried, we have sent stuff out, we have had it priced. And nobody wanted to help.
no participation.
No, sir. No, sir. And I mean, they were gonna do it all the way to the cul-de-sac. I don't know. I think his name is Francis, maybe lives at the cul-de-sac on the left of Green. And that's basically as far as we priced it. And it's about another 3/4 of a mile back to Michael Lawrence. And they pretty much take a Bobcat and do their stuff because a lot of horse trailers come in and out. There's a horse farm. But the front half, you know, it's bad. Thank God there's no snow because when you go toward 87, you sink up over it. You know, and I know, you know, we didn't have the time. I've got 2, or they're older girls now, but I know for a fact that Miss Honeycutt and her husband, they asked for help the other year, and they put $800-900 or something like that in rock on it, which that's almost 2.5 truckloads. You know, so I mean, traffic's an issue out there. I mean, you know, what can we do? We got big trucks. You got people in another part back there that they've been bringing heavy equipment stuff in. And I mean, if it gets approved by the county, we can't do anything about it. You know, we've even been asked the state to take the road over and sign the petition, the state will take it over. I mean, we're a tight knit community, don't get me wrong, you know. Not supposed to say anything unless it's about the road.
Thank you.
Yes, sir.
Is that all you?
Yes, sir, about the road.
Thank you.
Thank
very
you.
much. That's been very helpful.
All right.
Uh, Private roads, particularly that has upwards to 20 parcels on them, far exceeds what the criteria is for a private road. Even though the state allows 10+ acres to be exempt, that doesn't mean there's not traffic.
So how many lots, total pieces of property on the road again that are served directly by that road?
19.
19.
That's what I kept.
And how many are greater than 10 acres?
I believe,
It would have to be 6.
I believe
Because
that-
our calculation was there's 13 applicable lots.
I think
When you
it's
say applicable lots, you mean
Less than 10
lots that are less than.
And there is a lot. I drove nearly all the way to the end of that road. And you could, some holes, you could about put a beetle in, most likely beetle in. But, I noticed that there was, and I just looked here, it looks like it's a 5 acre lot, and somebody's already put 2 houses on it. And that was, I think, originally part of the subdivision provision. And, I'm assuming that they could do that, without splitting their property. If they could add a house of 5 acres, it'd be plenty of room, but they didn't do no subdivision. They just added another house on it. And,
So either way, you get additional homes because there's no prohibition on how many homes can be on an individual lot. I'd like to just ask a question, just back in 2022, was there some interpretation maybe that the former planning director had made regarding right of way and when you can count it, when you can't? And that's, I guess, for Ian to, if y'all ever discussed that.
Yes. So nothing particular comes to mind, sure.
I can only speculate because obviously I wasn't here at the time. But it seems to me in my reading of those old emails, I think it's accurate to say that the Rodriguez were given wrong advice about the interpretation of whether or not the right of way can be classified as part of the total acreage. But I would also say that they were given conflicting advice. Because that email specifically from Tanya, do we have that? Or did I lose it?
The one where she says to make sure all the lots are 1 acre.
Correct. Yeah, from May 23rd, 2022 at 3:46 p.m. Janet, also be sure that when the subdivision is complete, that the 2 lots each have a full acre since this is on a private road. Again, when I read through the thread, I see it as conflicting advice. And I don't want to make any kind of a negative judgment on the previous staff, because I think the work that they did was excellent in most cases that I've seen. Regarding your question on the interpretation, so if you look at subsection E there regarding private roads, you get down to item 6. And it says subdivisions accessed by non-conforming private roads shall be approved when the following conditions are met. The tract to be divided is at least a minimum of 60 feet of frontage on the road. An original tract of land adjoining a non-conforming private road may be divided utilizing the provisions only once every 2 years. The private road disclosure statement as provided in Appendix K shall be recorded. And D, all other provisions of this section are complied with. So perhaps Ms. Pershaw, and looking at just those 4 criteria, said, well, there's nothing in there about the 1 acre minimum. So I'm going to email and say, yes, I think it's achievable. Because if the determination is that this is a non-conforming private road and the 1 acre minimum is not mentioned in those 4 criteria, then perhaps she interpreted that as it wouldn't apply. But in my reading of that, where you get to the last item, it says all other provisions of this section are complied with. That to me, my interpretation is that the property within the right of way,
60 foot's got to come out.
well, the property within the right of way can't count towards the 1 acre minimum.
I think that section's clear that you don't include the right of way in your acreage. Acreage minimum, so. I just wanted some clarification if there wasn't some, and mistakes happen. And also in 2022, this ordinance was probably on the website.
Correct.
So anyone could have consulted it to make sure, the design professionals in to make sure. I get double checked all the time.
I believe in reading over the emails that Boswell Surveying actually did question twice about the private road acreage.
Had the applicants request to
That's
make
right.
sure before the.
That's exactly right.
They did that, I think, because, they knew what the ordinance was. And it seems to me like after they asked the second time, they were thinking, well, we might slide something back. And that's how I took it,
Yeah,
because the surveyors that, anybody would hire, they would have knowledge about the subdivision or
They should.
recombination, and they should be advising their client. And, so I would pass some of that on to them.
yeah, I think the county certainly bears responsibility from 2022 in their answers to Boswell survey. Does anyone have any further questions for Rodriguez's or the staff before we go into our deliberations?
I would like to give him one more opportunity to,
Yeah.
tell Will, hope you.
Everyone. Now, Mr. Rodriguez, is there anything you'd like to say about what has been said previously before we start the, once we close this down to just us talking among ourselves, we can ask questions, but you won't be able to, you'll just have to answer the question, won't be able to input. So I'm giving you an opportunity to say anything further that you'd like to say.
Okay. So I got a question about, when you did the, conflict of interest, when you like spoke that out, what does that like mean? What is that,
That means if we were kin to you,
Oh.
that there would be a conflict.
is it like personal friends?
Yeah, or kin or
Financial
a
interest.
financial interest, or if we work for the survey company that you have hired. It means that we would have knowledge about what's going on most likely. And so that's what conflict of interest is.
So I would like to ask about his relationship with, Eddie Vaughn. Is there any personal friendship there? Or, cause I don't understand how this guy went to the property and somebody must have talked down.
No.
How does that work?
Let me address that. We have the right and actually are somewhat encouraged to go out if possible and look at the property and see the property. Because sometimes when you're just looking at something on a piece of paper, it's really hard to tell what it means.
Right.
So, Mr. Owens certainly had the right to go and drive in and look to help him make a better decision here tonight. That's the purpose. Just like when I looked on the internet to the county's GIS, I wanted to see, all we had in our packet of information was just your little block. They're showing your house where it's located presently and a little bit more around it, but not nothing. So that wasn't enough for me. I wanted to see for myself, about how many houses was on the road already. And, I wasn't able to tell about the condition of the road. Thanks to the witness, he's enlightened us a little bit as to the condition of the road. One of the hurdles that you face is question number 4 about the safety issue.
Oh, yeah.
And I had mentioned earlier that, private roads historically can have problems with EMTs, fire equipment. And so that's some of the things that we have to take into consideration in making our determination.
Can I say that what he said about the road is not actually true? If someone go down right now, the road's not in bad condition.
Yeah.
They've been there's been a certain person, I don't know who it is, been, fixing the road and, I guess a couple months ago before I did uh, the application for the subdivision, they said that, there was a developer that just built a lot back there. He fixed the road in order to get that parcel subdivided. So
Uh,
it's been a couple months where it's been improved.
that was the reason I asked you earlier tonight. If you had a formal road maintenance agreement that you was aware of. Now, the witness said, you know, that there has been an effort to get the property owners together to do something to keep up with it. It's not unique to L Lawrence Trail that it's a maintenance problem. And it's also a big hurdle to get a road taken into the DOT's maintenance program. That's a big hurdle. And we don't need to address that here tonight. Any other? questions? Or,
What was I gonna say? I just want to say, I don't have pictures of the road, but there's nothing wrong with the road. I don't know what he said about erosion on the side, but the road's perfectly fine.
and
It has no,
your opinion.
well, apparently to the planning department for them to let the developer, I guess, subdivide the land, they had to do a improvement. I guess they had to improve the road. So I don't think in a couple of months that road will automatically just be unsafe or.
The problem is, from my personal perspective, is on down the road about what's gonna happen in the future with it. We already know that there is a road maintenance agreement in effect since 1995, 1996, something like that, that has not been upheld. And we do fortunately have a member that went out and looked at the road himself. So,
Okay, so, quick question, what if, like, what can I do if, what is the process if there is a person, I guess, conflict of interest on your, I guess, panel?
I'm not sure what that process would be. I think it would be a legal process. You would have to hire a lawyer, an attorney, and say that you think you were probably mistreated. And that would probably be when you would have appealed it to Superior Court. And that person could be subpoenaed to court and would have to testify as to whether or not, he had any conflict. I don't see that there would be any advantage for any of the members of the board not to say if they had a conflict, because that's the reason we have a couple of alternate members. So if Mr. Cobb had a conflict of interest, he would speak up and say, look, I don't feel comfortable here tonight because I put your septic tank in. So I'm going to recuse myself tonight, and then I would have appointed, just like I did with Mr. King tonight, because Mr. Wilson wasn't here early enough. And so that's how that's handled. So to the best of my knowledge, and it may be a question for the attorney as to if he wanted to question whether or not any of the board members has a conflict of interest, that his next step would be to go to court, right?
At this point in the proceeding, I think that's correct. He should allow the proceeding to continue, and that would serve as a basis for approval.
Right. That's so if you feel as though someone on this board has a potential conflict, then I would encourage, if we don't make a judgment in your paper.
Right.
I mean, there's not been any decisions made yet.
I know, I'm
Yeah.
just because
Yeah,
I
yeah,
got a
yeah,
gut feeling there's
Of
there's
course,
a little.
I understand.
Okay,
I understand, I understand where you're coming from, no problem. No
Yeah, I was just, yeah.
We all got thick skin. Okay, any other questions? for us?
Oh, that should be it. Cause I'm guessing, can you, uh, can you, like define hardship? The word hardship on this?
Uh, and that's a tough, okay? Uh, unnecessary is the real question. But a hardship is when it's, something that makes it harder for you, for example, I would say it's somewhat of a hardship if you want to, cut a lot off and you're not allowed to. But that doesn't mean that hardship will give you a variance.
Right,
There's different types of hardships, you know, so that's not an easy thing to define.
I would say, how is the ordinance a hardship in your particular case, where it would be a hardship to anyone else? Similarly situated in your position.
In other words, how would this be unique to you? How would this cause a problem for you that it wouldn't cause for somebody else in that situation?
Oh, okay. So I'm guessing.
Is that right?
That comes with the.
Tom? Is that
Yes, I mean, there's another similarly situated lot that's down from this that's about the same size. There seems to be two panhandle lots, and then the Rodriguez, and then there's another one on the further west.
Okay. Well, I guess based on, since it's 2.04 acres and not including the road, which I guess that's the only, I guess that's was unique, I guess the, size of the lot and, I guess the size of the roadway, the right of way.
Yeah, you stated that.
Yeah, okay, so yeah.
We understand.
Yeah, that's pretty much it, Dan.
Can I address that?
Yes, sir.
Your property is not unique. There's other properties in that same subdivision, as a matter of fact, same size as yours, that has the same issues yours has got. The same, it's 2 acres, and the road is going right through the property. So, you know, for us to apply it, is, you know, and the plan's gotta be peculiar. Well, yours is no more peculiar than the lot right below yours. It's a 2 acre. Those people have the same hardships that you trying to say, if they want to say we want to subdivide. So we gotta follow the letter of the law.
Right.
And unfortunately, your lot's not different. If it was the only one in there like that, then we could say, yeah, his lot's different, but it's not.
Can you show me which lot you're speaking about?
Pull it, yes, of course. You're referring to this lot, correct?
Yes, it's the same thing, same acreage within a tenth. And so that's what I'm trying to say. Your lot is no different than your neighbor's lot.
Right.
Now, if your lot was the only one in there like that, you would have a standing argument on that, but you don't. As a matter of fact, that's the statement I made earlier. All those properties, that road is going through them. Everybody in there has that road as an easement. So that's another thing you have in common with all your neighbors.
Okay.
Yeah, that's why I asked the chairman to give you more opportunities, because this is a hard hurdle to jump over, those 4. You might get 2, you might get 3. It's hard to get all 4.
Yeah.
And I think we've gotten in the weeds on the road itself, which is not the subject.
It's not part of hardship.
It's the
But
right of way being included in the lot area.
But letting him speak though was part of the law. In other words,
Yes.
those 2 people did have standing. I'm trying to go by this, the case it is a people, because those people can go to Superior Court and say, look, we have a standing issue, and it's actually in black and white. That's the reason I argued for their benefit to speak. That's actually to help him that goes to court.
I agree.
Can I say, when speaking about the road or whatnot, I'm allowed to put a home back there even without being subdivided, so the traffic is gonna be the same amount of traffic if it was not subdivided, it's the same thing.
We don't have to do that.
I'm just saying, cause I already got a permit from the environmental health that I could put a home back there. So I wouldn't even,
Yeah, we understand. It's a deal with the bank. It's
Yeah, that's-
what you- Yeah, we understand. We understand. Any other questions for us?
no, that should be it.
Does the staff have any further thing to add before we go into the,
No,
Well,
yeah.
actually, yes, I guess one last thing on the road, as, I guess, as to attest for its condition. Back in, and I do not remember when the subdivision plat was submitted or the proposal was submitted. But back in September of 2022, a subdivision was approved for these lots back here off of El Lawrence Trail, and I believe two up here off of John Glosson. Where it was required for that developer to extensively improve the road up to this cul-de-sac, and that would have been investigated by the deputy fire marshal at that time. That just have that on record. That is why, I guess we had considered this no longer a non-tolerant.
And I'll just add to that, I mean, there are innumerable aspects of a subdivision that we review prior to final approval. Road conditions, proper certificates, proper plat layout, size of the lot, setbacks, easements, things of that nature. So it's just a little bit of a separate issue than the two specific variance criteria that are being discussed tonight.
that it?
I believe so. Yes, sir. That's all I've got.
Okay. We'll move on to our deliberations. I have personally question number 4 or hurdle number 4 is a big deal for me about the safety. Mr. Owens has already commented about he went out and actually saw the road conditions. So, question number 4 means a lot for me. And to paraphrase it a little bit, requested variance is consistent with the spirit, purpose, and intent of the regulation such that public safety is secured. That's the word, public safety is secured, and we don't have any means of doing it. You know, so I think there's a safety issue. Personally.
I get my question or my thoughts on that is, you know, to consider what's the purpose of the 1 acre minimum lot size on the private road, and 2, why the area in the right of way matters. So I guess that's would be a question I would have. It's very common in subdivision regulations for you, or in also zoning regulations, where you don't count the area in the right of way for the minimum lot size. So I kind of understand that.
So that's black and white.
Yeah, that's black and white.
That's
That's fairly common.
Yeah, that's black and white. The other issue with me is, and it certainly has some bearing with me, is that Mr. Rodriguez had some bad information given to him in 2022. And since that time, he's gone forward, obviously, and spent money based on what he was told in 2022, that it could be subdivided. So that's a consideration that I have. You know? I mean,
Am I allowed to make a comment real quick?
no, no,
Okay,
I'm
okay.
sorry.
Okay,
I'm sorry. So, you know, that's part of my feelings that, you know, our job is to weigh the evidence and hopefully come up with something that's reasonable. But that's a big factor. You know, you come up here, you don't know anything about subdivisions, and you come to the staff, and whether it be through a surveyor or not, and you're given information that's not correct, but you proceed on the information that they gave you, and you spend money to do that, that's the deal. You know, that's to me a hardship if you're not able to do what you want to do ultimately. After the people that had the authority to let you do it, for lack of a better term, changed their mind. And I know that didn't happen. But you know, all of a sudden the county, no, we're sorry. We can't do that, you know? So that's something in my mind that I think bears some consideration in this particular circumstance. You know, I can say this, if it wasn't for that, for me personally, it would be cut and dry. You know, they ain't gonna have you know, the ordinance or the UDO is clear about it. That right of way cannot be considered. So that to me is a cut and dry deal. But because they were given, no offense, but given bad information, I think that's a factor that we need to think about, you know? I mean, I'm not trying to step on toes, but I feel like that has a bearing on it because he has spent money because of that, because of the bad or faulty information he was given.
So that would be for number 3, the hardship is not the result of the actions taken by the applicant of the property owner.
Right. Right? Like I used to go to the planning board, what's your feeling about this? You're in deliberations among yourselves.
Ian, from the beginning in 22, was the understanding as implied by those emails that Rodriguez could move forward?
I'm guessing I'm allowed to answer a specific question.
Yeah.
I would assume that's a fair assessment, since that was what their surveyor was told,
Okay,
essentially.
so, and I understand exactly what Mr. Holt's saying. The way it's looking to me is if the county representative authority had made the statement via email, telegram, home invasion, that they could move forward. And then once they get started moving forward, now all of a sudden, hold on, wait a minute, we're gonna have to put the brakes on it. My mind says that they were misled from the beginning. That's what I say.
Yeah, there was certainly a mistake.
And mistakes happen. Okay, it's not perfect world we live in. But you wanted my thought there, it is.
Certainly. Ms. Hyder, you've been quiet all night.
Yeah, I'm listening.
Yeah,
I've got confused a couple of times
okay.
with the road and
Well, maybe we can clarify something. Ask questions.
Well,
Where you can, what you
I
confused about?
was confused about the road is not good. And you were talking about like a ambulance couldn't get in there, you know.
No, it's not that bad. It's not,
It's not.
no, it's not kept,
That was.
that road
concerning.
is not kept up. It's
Oh.
very passable. When I was in there that day, I met 2 horse trailers coming out of Seaway Park too. So it's very usable. It's just not kept up. The road is not kept up.
When did you go down?
2 days ago, maybe. Yeah, I just rode, I didn't go all the way to the end. As a matter of fact, the further I went, the worse it got, you know. From the
Beyond the cul-de-sac
yes, and,
to the big track.
but from 87, it's just, I guess the best way to put it is lacking gravel. And
I
it's just
believe-
not kept up. That's just my opinion.
The reason I asked It was January 22 when I was in. We parked our roadside lowboy right there at the NLR trail right there at 87. We had to drive.
At the
our stuff.
beginning, at
At
the
the
beginning.
beginning,
Yeah.
because the further you go up Alamance Trail, the worse it gets.
That's where I found it, but that was way where it made that sharp turn.
Before you get to that sharp turn, there's an imprint of a cul-de-sac right there.
Well, it got rougher after you made that sharp turn. I don't even know if that was initially part of the original subdivision or not. But from 87 to that point, it's like it needs gravel. It ain't like it's, coming apart.
Washed out.
No.
Well, I did notice up near the cul-de-sac when I was going in over there was some. Pretty good size. But. That's been a couple years.
And what was your other concern?
Well, that was mainly
Okay.
the road being bad.
So did Mike help you out there, what he said?
Yeah, it is.
Mike, any, what's your opinion?
Are we addressing number 3?
No, we're just talking now.
Okay.
Then we'll come back and address them individually.
Well, I agree. I mean, I think they do have, unintended hardship that they didn't put on themselves. And it's a shame they can't make the county pay. I don't know how much it's spent, but it's a shame that you can't. But, and on number 4, I don't think there's a safety issue,
Okay.
at least not. I don't
Present.
think- Yeah.
President.
So I think that in the spirit of his request, I think it's good. You know, that, well, I got a problem is the first 2, you know, I just don't think these mechanisms they follow.
Can we go back to number 4, just for a minute?
I don't think it's meant.
There are several large pieces of property on this road. This is a non-conforming, has been deemed a non-conforming. No,
Not currently, no.
not currently, so now it's a class 2.
Yes, and to further clarify, it would have been around August, September, when that, I believe 3 or 4 lots off of Lawrence, 2 off of John Lawson, were approved. So around August, September
So
twenty
improvements were
twenty-two.
made, and
Yes,
at some point, no more lots. And you have to bring the road up to public road standards,
The
Yes.
15th lot.
the 15th lot, and we're at 13.
13.
13
Applicable
currently
lots.
applicable lots.
Okay,
And then I feel it might be need to say this. I understand that the road is an issue, but road requirements and requiring subdividers to become parties to a road maintenance agreement is also part of our review process. When we go through the process of reviewing preliminary plats. Just because it is not evident in our emails or jumping off the page in the documents that we've shared with you, doesn't mean that it's not part of our ultimate process before a subdivider is granted final approval. The 2 issues that hung up the process were the minimum lot size. And help me out here. Yes.
Yeah.
The 2 specific criteria that we're discussing for the variance. So I understand that the road is an issue, but it is also part of our review process prior to final approval.
so there's a mechanism in place to maintain that road. The fact that it's not being maintained is not something we can solve.
We understand that there is an existing road maintenance agreement for that road. One of our procedures prior to final approval would be a certificate going on the final plat and the signature of the subdivider to bind themselves to that road maintenance agreement.
yes, and that was the same for that, September 2022 plat as well.
The issue here may be that we just didn't really get to that part of the process because we got hung up on these other 2 issues. Does that add some context to the road issue?
My question goes back to, you know, you're just telling the reasons why they were turned down. But what about, we talked about earlier about the restrictions, say no future re-subdivision. I mean, can you address that?
Yeah, I think that's an excellent question. So Ian, you might be able to address that a little bit better than I can. Let me share just what I can briefly. So if there's an existing lot that was created years and years ago, perhaps it was created prior to that becoming a requirement of the subdivision ordinance. Perhaps it wasn't. Even if it was created and that rule should have attached to it and attached to its deeds, I don't know that we can retroactively go back and require that lot to adhere to that rule. What we can do is any future lots that come our way, whether it's this one or any other, we can ensure that something like that is in place prior to our final approval. So similar to the road situation, we would look to ensure that that is adhered to prior to the final approval.
Well, so I guess my question is, so you're not saying it's necessarily recorded on his deed?
Correct. I'm not sure if it is or isn't.
Ian, when Alamance Trail, when was that originally subdivided?
1995.
Well, the four lots around the, the property commission, that was 1995 or so. The other lots along the road, I do not know. We did originally, I did mention, we did originally say it was non-conforming private road before the upgrades happened. So that would mean the road was in place sometime before, at least way before 1974 or so.
74 or 94?
The 74, because for a non-conforming private road, it had to have existed before the subdivision
Okay.
ordinance.
All right, so-
Yeah.
So we've got deeded lots, we're gonna say from 95. So that's 29 years ago. Mr. County Attorney,
Yes, sir.
if there's a deed restriction or if there's a restricted covenants on a deed concerning subdivision, do they not have to be renewed every 25 years?
Yes.
So if the deed restriction that you're talking about was there in 95, if they were not renewed, they have expired.
No.
They're null and void. They don't count. Is that right?
That's new information for me. I
Am
wasn't
I
aware
right,
of that.
Mr. County
I
Attorney?
wasn't aware of that 25 year.
I believe that's correct.
It's my understanding if they're not renewed, then usually there's a sunset. They call it a
Whose
sunset.
responsibility is it to renew it?
Anybody that lives on that property in that subdivision, any one of them could have it renewed.
And it would affect everyone in.
And if it is not renewed, if you have a subdivision that hits the ground this week, in 25 years, the restricted covenant will expire unless they are renewed. And that is fact, I believe.
Wonder what about a separate road maintenance?
That's a
Because
separate,
it's a separate document.
that's a separate document that's specific to maintenance of that road, and that can go in perpetuity.
Okay.
And plus, we have no jurisdiction over restricted covenants, so.
Right,
it's
right.
good to know.
I was just wanting that for my information itself. Okay. Any further discussion? Are we ready to get down to the nitty gritty here and start breaking out these things one at a time? Yes.
Commissioner.
Mr. Chairman, if I may, I'll just briefly mention, each of you should have a worksheet that Mr. King, put together, that gives you space under each of the variance criteria. If that's a helpful tool for you, then that's there at your disposal.
It's worded a little bit different. It doesn't have quite all the wording that you included. But I think all of the basics are there, so I think it's good. I think Tom did a good job.
Yes, sir. And I'll be happy to read any of the variance criteria or any other general statutes. If that's helpful.
Okay. Right, according to the county attorney at our last meeting, we do not need a motion and on each one of these items, we can just do a straight up down vote on them and then vote at the end. So on item number 1, concerning unnecessary hardship will result from the strict application of the regulation. I'll be glad to entertain a motion on question or hurdle number 1. Unnecessary hardship will or will not result from the strict application of this regulation. Any motions? We've got to decide here.
I'll make a motion that unnecessary hardship will not result from the strict application of the regulation. There's been no evidence that presented that there's a unique hardship that wouldn't be suffered by other residents on the road that we wanted to subdivide. We're in a similar situation as this, and there are lots of similar sites.
Is there a second? Without a second, Mr. King's motion dies.
I second it.
There is a motion and a second that the unnecessary hardship will not result from the strict application of the regulations. Based on Mr. King's opinion, because there's other lots in the subdivision of equal size, that it's not unique to Mr. Rodriguez's property.
Well, not only that, he's
Got
got,
to do the motion. Got to do the motion. Any further discussion? All in favor of Mr. King's motion, say aye.
Aye.
All opposed, nay. Ayes have it unanimous. Question number 2. The hardship does or does not result from conditions that are peculiar to the property, such as location or size in this situation, or topography. The hardship does or does not result from conditions that are peculiar to the property, such as location, size, or topography.
I make a motion it does not.
Is there a second?
Probably need to make a finding as to why.
Yeah, thank you. What's your finding? What's your reasoning for that, right?
Because it says so right here, the hardship does or does not result from conditions that are particular to the property, such as location, size, and topography.
Right, but what's your reasoning for think that it does not?
Because with the point that Mr. King made earlier about the other properties that are already there, that wouldn't be able to do it either.
Okay. So there's other people, other lots that are equal in size.
That's correct.
So
That's my-
that's. Okay,
So would that be does not?
that's the motion he's making.
Yeah.
I would also,
That's
think
good.
there's no evidence presented to show any physical hardship with the property. This just happens to be a situation where there's not enough land area to meet the ordinance requirement.
Are you willing to incorporate that into your motion?
Yes, sir.
Okay, is there a second?
So
Okay, there's a motion and a second that the hardship does not result from conditions that are particular or peculiar to this property, such as location, size, or topography. Mr. Cobb says that he believes the reason is because same as it was in question number 1. There's other lots in there that's similar. Mr. King added to that motion that it has not been proven this is any kind of hardship. Any further discussion? Any discussion? All in favor of the motion, yes.
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 All opposed, no. Did it show unanimous that yes? The motion passed. Question number 3. The hardship is or is not the result of actions taken by the applicant or property owner. I'll be glad to entertain a motion.
I make a motion that it did not result in his actions.
Second.
There's a motion and a second on the floor that the hardship is not the result of actions taken by the applicant or property owner. Any further discussion?
I'll show the state, we make a finding of fact that the applicants did pursue this subdivision based on erroneous information provided by former planning department staff. They were told the area in the right of way could count toward the 1 acre minimum lot size on 2 subdivisions in 2022.
Okay. So you wanted to amend the motion?
I just wanted to state the finding,
Okay,
not only the motion.
okay. Any further discussion? Okay, all in favor, say yes.
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 All opposed, say nay. Unanimous. The requested variance is or is not consistent with the spirit, purpose, and intent of the regulation, such that public safety is secured and substantial justice is achieved. The requested variance is or is not consistent with the spirit, purpose, and intent of the regulation, such that public safety is secured and substantial justice is achieved.
I make a motion that it is.
Is there a second? And what's your reasoning, Mike?
I've been on the road with this safety travel.
Okay. So there was a second by Mrs.
Yeah.
Hyder.
You know, when they were talking about, the road is that bad.
Okay. So there is a first and a second that the variance is consistent with the spirit, purpose, and intent of the regulation, such that public safety is secured and substantial justice is achieved. Any further discussion? All in favor, say yay. Nay.
Yes.
All opposed, no. Unanimous. Okay. We need to take one more look. I'll be glad to entertain a motion as to whether we approve or not the applicant's petition for a variance. I think it's the writing's on the wall here, but I mean a motion.
I make a motion to deny the variance, requested variance on the basis of findings of fact numbers 1 and 2.
Okay. Is there a second? Need a second here.
I say,
There is a motion with a second that we deny the request for a variance based on question 1 and 2. All in favor of the motion, yay?
Yeah.
All opposed, nay? Let it be shown it's unanimous. Mr. Rodriguez, what has happened here is we have found that your application does not meet the criteria to issue a variance. Should you not want to accept what we have said, you certainly have the right to appeal it to Alamance County Superior Court. Again, I want to say that we have to find our findings on fact. It's not personal deals, so that's the case. Thank you.
I will add that the next step, we will have to draft a written decision document that will need to be reviewed by the board. And once the board has approved that written document, the chair will sign it and it will be delivered to you. And that will be the point where you can file an appeal with Orange County, Alamance County Superior Court. If you want to, and that appeal will be in a review of the record of this case
tonight.
of what was done tonight. So if you have a feeling the board didn't operate correctly or
Conflict of interest,
conflict of
any of that
interest,
stuff.
and the court will review that record and they'll make a decision. And if they believe the board made the decision incorrectly or there were errors in the procedure, they could very well remand the case back to the board to rehear it. It could be remanded back saying you really messed up, grant variance. But once you get that written decision, you'll have 30 days to file that with Alamance County Superior Court. It's called in the nature of certiorari, means a review of the record.
Okay.
Is there any further business before the board?
Tom took the words right out of my mouth. Probably said it a lot better than I could.
Sounds like he's had experience, though.
I think he has.
All right, well, I appreciate the board's participation. Thank you all. I think it was a productive meeting. And I'll be glad to entertain a motion to adjourn. Second? There's a motion and a second to adjourn. All in favor, say aye. All opposed? Unanimous.